And today we're talking with Kirk Tarman, a criminal defense attorney in San Bernardino and Riverside County, Southern California. And we're going to talk about something that's obviously the hot topic today in the news. And that is what happens with a jury when they can't get a unanimous decision. We've got a criminal case that's going on, Kirk. Well, first of all, welcome. We've got a criminal case going on in New York right now, where the jury is unable to reach a verdict. And one of the headlines in the news articles that came out, it said they can't reach a verdict on the top charge. And you and I both know that when the prosecutor charges a criminal defendant, he may or may not have multiple charges. So I want to pose this question to you. Does a prosecutor throw in like a shotgun effect? We're going to throw a lesser charge up there just in case the jury doesn't find enough evidence to charge at the top charge. And then, the highest level, do we go down a little bit then? And does it even go down to a third level? Or is it, one shot and everything's over?
And that's a good question. And it really depends upon the type of case that it is. Many times the defense attorney wants a lesser charge to be included in the jury trial so that the jury has the ability to fall back to that lesser charge. Okay. Sometimes the prosecutor doesn't want the jury to have that option so that they have either a yes or a no, a binary option. He's either guilty of something or not guilty of something. A lot of the time in murder cases, you'll have that. A murder case, you can charge attempted murder, batteries, assaults. You can do voluntary manslaughters. All of these things are something that are all what are called lesser included charges to what are called the umbrella charge, the highest charge. So a lot of the times as a defense attorney, what we do is we know that there is some weakness in the prosecution's case. We know that a weakness in the prosecution's case will allow the jury or will cause the jury to have some problem with the conviction of that top charge. Let's just say the murder charge. And so if that weakness is something that we feel allows the jury a true opportunity and a reasonable conclusion of one of these lesser charges, and we're good with that lesser charge. Because voluntary manslaughter is a significantly less amount of time a person is exposed to if convicted rather than a murder charge. In California, it's life. Voluntary manslaughters, there's involuntary manslaughters, voluntary manslaughters. Each one of those has different reasons why they exist in the eyes of the law. Are significantly less amount of time. You do half time in California with those. They're not always violent or serious penalties. So a lot of times it depends upon the perspective of both parties. Sometimes defense wants those lesser charges in there to give the jury that option if the defense attorney feels that that's a good outcome. Sometimes the defense attorney doesn't want those lesser charges because they feel strongly about being able to win that what we'll call the higher charge, the top charge. And a prosecution may feel the same. Okay. The prosecutor may feel like if the jury is given an option for a lesser charge based upon a number of reasons, sympathy for the defendant, things along those lines, they don't want to give the jury that option. They want to lock them into having to make the hard decision, yes or no, on the one charge. So each one of these things is a tactical decision from the defense or the prosecution and whether it's going to be included. So
obviously the first bite at the apple comes from the prosecutor, depending upon how many charges are filed. And but obviously the defense doesn't have any say in that.
They're just hoping.
That's incorrect.
It is.
Well, yeah.